We start. Justices J.B. Pardiwala and Manoj Misra at the Supreme Court have affirmed in the judgment of the case Messrs. Poly Medicure Limited versus Messrs. Brilio Technologies Private Limited on November 13, 2025 that both the State Commission as well as the National Commission were justified in holding that the goods services purchased availed by the appellant were for a commercial purpose and therefore the appellant is not a consumer as per section 21D of the Consumer Protection Act 1986 para. In this case, the complainant appellant herein has been an established company doing business which bought the product license to automate its processes. In such circumstances, the object of the purchase was not to generate self-employment but to organize its operations with a view to maximize profits. In the court's view, therefore, the case of the complainant does not fall within the explanation to section 21D of the 1986 Act para. In the Supreme Court decision of the case National Insurance Company Limited versus Harsolita Motors and Others 2023 8 SCC 362, another decision relied upon by the appellant, the complainant, a commercial entity engaged in the business of selling vehicles, took fire insurance policy from the appellant, an insurance company covering its office, showroom, garage machinery lying in the showroom premises, etc. The complainant's case was that damages were sustained during Godhra riots and therefore the complainant was entitled to be indemnified under the policy of insurance para aggrieved by the action of the insurance company claiming deficiency in service. A complaint was filed. The insurance company took an objection that the complainant was not a consumer as per section 21D of the 1986 Act because its ultimate aim to earn profits. The State Commission upheld the objection against which the complainant filed an appeal before the National Commission para. The National Commission held that the expression used for any commercial purpose would mean that the goods purchased or services hired should be used in any activity directly intended to generate profit, but in a case where goods purchased or services availed are not intended to generate profit, it would not be a commercial purpose. Therefore, it was held when a person takes an insurance cover for indemnification of actual loss suffered, the intention is not to generate profits. Consequently, the complainant would be a consumer. Upholding this view of the National Commission, the Supreme Court observed, applying the aforesaid test, two things are ruled out: whether the goods are purchased for resale or commercial purpose, or whether the services are availed for any commercial purpose. Twofold classification is commercial purpose and non-commercial purpose. If the goods are purchased for resale or for commercial purpose, then such consumer would be excluded from the coverage of the Act of 1986 para. Similarly, a hospital which hires services of a medical practitioner, it would be a commercial purpose, but if a person avails such services for his ailment, it would be held to be a non-commercial purpose. Taking a wide meaning of the words for any commercial purpose, it would mean that the goods purchased or services hired should be used in any activity directly intended to generate profit. Profit is the main aim of commercial purpose, but in a case where goods purchased or goods hired is an activity which is not directly intended to generate profit, it would be a commercial purpose para. What is finally pulled out is that each case has to be examined on its own facts and circumstances, and what is to be examined is whether any activity or transaction is for commercial purpose to generate profits, and there cannot be a straitjacket formula which can be adopted, and every case has to be examined on the broad principles which have been laid down by the Supreme Court para. Based on her Solita decision, the appellant counsel submitted that if the goods purchased or services availed for convenience, comfort, or for better management of the business of the company, and the complaint is filed for compensation on account of defective supplies or deficient services, a consumer complaint would be maintainable para. If the transaction has a nexus with generation of profits, it would be treated as one for a commercial purpose. Whether a transaction has nexus with generation of profits or not is to be determined on the facts of each case by taking into consideration the nature of goods purchased or services availed and the purpose for it is purchased or availed. If upon consideration of all relevant factors the picture that emerges is one which reflects that the object of the purchase of goods services is to generate or augment profit, the same would be treated as for a commercial purpose.